Everyone, good morning. Welcome to the 2024 Mid Year Labor Law Update. Today is sponsored by your Central Valley Regional HR Hotline. My name is Anna Manzano. I'm the Digital Media and Event Strategist here at the California Employers Association. Before we kick into today's content, I have just a couple details to go over with you. So, as you see, your audio is muted for today's presentation, but as you're already doing so in the chat, there is going to be lots of opportunities to engage during today's session. One of the ways is probably going to be asking questions. So if you do have questions about the content, you can put them into the Q&A box at any time. I'll also be watching that chat box. So if they end up in there, I'll make sure that we try to get your questions answered. But the best place to put them is gonna be in the Q&A box, so we have a running record and we can make sure that everything gets answered. Handouts for this training, those were sent out in yesterday's reminder email. But I know we did have a few last minute signups. So what I'm going to do is in a minute or two, I'm going to put the PDF into the chat box. So once you see the little file pop up, you can just click on it and then it'll download locally to your drive. If you have any trouble accessing it, just go ahead and shoot me a little message in the chat and I'll make sure that you get that, okay? Last but not least, we do have a survey. So it is 5 questions, takes less than a minute and a half to complete. But the feedback that you share with us in only those 5 questions, we then share with our partners over at Central Valley, and we make sure that we are collectively meeting and hopefully exceeding your expectations with your HR hotline, making sure that we give you trainings like these that are really helping you run your departments and companies with more peace of mind. So if you could take the minute at the end, there'll be a QR code on the screen. I'll also drop a hyperlink into the chat. Now I have the great privilege of introducing our trainer today. We have Eli Nunez, who is one of our HR directors, who if you did utilize or have utilized the HR hotline, and I really encourage you to do so, maybe you have spent some time talking with him. So I know we have so much to cover and it is all yours, Eli.
Thank you very much, Anna. Thank you. Welcome, everybody. Welcome to this major labor law update. First of all, I'd like to thank the Central Valley counties that have taken part of this hotline and provide you some information as well. If you have any questions either about the presentation today or any other HR subject, please call the appropriate hotline for your county. We're here Monday through Friday, 8 a.m. to 5 p.m. to answer your questions. And that could be anything from, leaves of absence, FMLA, paid sick leave, employee handbooks, harassment prevention, investigations. Whatever HR topic you have a question on, give us a call. We're more than happy to answer your questions or even just hear you out if you just want to talk over something HR related and need another set of ears to kind of sort through it. That's what we're here for. We're here to help with you with any HR topic or subject that you have. A little bit more about us. We are California Employers Association. Some of you may be familiar with us, been dealing with us for a while. Our goal is really to provide all our members and all our callers with peace of mind. So we do that by providing HR compliance solutions, trainings, webinars such as this, recruiting services. Basically, what we try to do is we try to help you out with any of the heavy lifting on the HR side so you can focus on running your business, running your organization. We know human resources can be a complicated subject, so we are here to help in any way that we can. Having said that, though, one thing that we are not is we are not lawyers. And even though we do have people on our team with legal experience, any advice, any presentation, anything we give is basically presenting you with information, kind of an educational basis as opposed to legal advice. We do recommend if you have any questions of a legal nature that you contact or retain your own legal counsel in order to fully discuss those subjects or those topics and have that attorney-client privilege and other things that a lawyer can provide that we cannot. So with that, now we got all the fine print out of the way, if you will. Let's go ahead and jump right into our presentation. Today we'll be covering several subjects all over the place, things that have changed from the beginning of the year till now. We'll start with wage and hour updates because that's something that affects us on a day-to-day basis. Talk about the workplace violence prevention plan, which is a new requirement that came into play mid-year. Some new rights for pregnant workers, and also some FAQs or some topics or subjects that we get a lot of questions on the hotline or things that we think are very important to discuss. So with that, let's go ahead and get started. We'll start with wage and hour updates, talk about local minimum wages, compensable time, and other topics related to that. So first one, and even though this isn't new, it's always good to review, it's talking about the California minimum wage. So as you know, as of January 1st of this year, minimum wage was $16 for workers throughout the state, or 66,560 for exempt or salaried workers. Now, there are other minimum wages in other industries. The fast food industry comes to mind, for example. But for general industry, it is $16 an hour. So, thing to keep in mind too is if you have any exempt employees that aren't hitting that $66,506 threshold, then you have a couple options. You can either raise their salary so they hit that mark, or you can consider moving them back to a non-exempt or hourly employee. Now, this is actually easier than it sounds because in the state of California, all employees default or are considered non-exempt unless you can prove that they are exempt. So it's easy to basically transition them back, if you will. You see a bit.ly link there. We actually have some tips, a fact sheet with some tips and tricks when it comes to transitioning exempt to non-exempt employees, especially when it deals with employer relations, right? Because again, if you go from an exempt to a non-exempt position, there's other things that come with it. Not only are you having to clock in and out now, but you also have to take your meal periods, your breaks, all that sort of thing. And in many cases, people may consider it or feel like it's some kind of demotion, right? You're going from an exempt position to a non-exempt. And even though that's not the case, that's a feeling that may kind of slip in there. So you have to be very careful with the messaging and how you communicate um, that transition. So we can help you with that as well. Now, California being what it is, it's not as simple as having just the one minimum wage throughout the state. There are also several other localities, municipalities, cities, whatever you will, that have different minimum wages throughout the state. So what the state does is they give us the floor. The minimum that you can pay somebody is at $16 per hour, but then different cities or industries or, counties have the ability to pay beyond that. So as of today, we have over 40 local ordinance that could apply when it comes to minimum wage, paid sick leave, predictive scheduling, or flex time. So there is a lot of variation throughout the state, right? And a lot of these places actually had increases July 1st. So not only do you have that January 1st increase to worry about, but if you do business or have employees in these locations, um, you have to worry about that July 1st increase as well. And the thing to keep in mind is that the local minimum wage is based on where the employee is physically working. So first thing that comes to mind is if you have any remote employees that work in one of these locations, then they are covered by that minimum wage and possibly those sick leave or flex time protections as well. So for instance, if your business is based out of the Central Valley, but you have an employee that works remotely out of San Francisco or, Emeryville or something, you have to be aware of what their minimum wage is and what their, other protections are there because since they are working remotely, that is their place of work. So, you know, that is that is what they should be paid. Now, question just came up, which I'll go ahead and address right now. It says, when you have an exempt employee, how do you protect the company from not having that employee come back years later and say that they want hourly or that they should have been hourly employees? And the thing to keep in mind is with exempt employees, in order for them to be considered exempt, they have to meet two requirements. One is that minimum wage, that minimum salary wage that we talked about. The other one is the duties test, the exemption. So, we do have some worksheets available or some spreadsheets available on our website that you could kind of work through there to see what kind of exemption applies. So, for instance, if they are in a managerial position where they manage several, employees below them, they can basically make recommendations or have effects on their wages, their continued employment, that sort of thing. If they're managers and they meet those requirements, then you can document that and prove that they are in that position. So that kind of shows why that position is exempt. So really, the burden of proving that the position is exempt really falls on the employer. The employee can ask otherwise, but as an employer can determine on each position based on the responsibilities and the duties, as well as that meeting at least that minimum wage, that it is an exempt position. So as long as you can prove that, you are you're well covered from that employee coming back later and claiming that the position should have been non-exempt. Just be very careful again if those duties change or if any kind of responsibility changes with that position, make sure you're documenting that and analyzing that every time to make sure that it doesn't affect their exempt status. Now, again, back to July 1st increases, some of the places that we saw these increases come into play. In Northern California, of course, you have, your usual suspects, right? Alameda, Berkeley, Emeryville, Fremont, Milpitas, the city of San Francisco. In Southern California, we have Los Angeles, both city and county, with separate minimum wages, of course, just to just to keep it interesting. Malibu, Pasadena, Santa Monica, West Hollywood hotels. Again, there's one where it just applies to that certain industry in the locality. So follow that bit.ly link if you want to see, what all the different minimum wages or different increases are throughout the state. And again, be aware if you have employees that go into these locations. Things that come into mind are, for instance, you have like a landscaping company and you send your landscaping crews into the Bay Area to do work. Be very aware of what those minimum wages are over there and those protections, because if they're performing work in those areas, then those protections do apply to them. All right, so in dealing with wages, wage and hour, that sort of thing to keep in mind is the way this is determined is, first of all, there's laws that are passed, or policies or labor code, right? But then sometimes cases come along and they interpret the code in different ways, or they basically put it in a new light, and that kind of establishes what the rule of law is at that point. So in this case, we have this question that says, before our employees start their day, we have a security screen process. Employees must scan their badges and go through a bag check and metal detector. The process is about 5 to 10 minutes each day as the line forms. Employees then clock in to start. Is this okay? So in many cases we thought, well, that's just part of coming into the building. That should be okay, right? It should not be an issue. Well, unfortunately, we had this case that came across this year in Huerta versus CSI Electrical Contractors, that basically reminded us that your employees, they shouldn't be engaging in any kind of pre or post shift work that is off the clock. So in this case, that example is probably not going to fly. Now, keep in mind that this case was a very specific set of facts, very specific details, but it kind of shed some light into the whole situation and where the state is going, or which way the state is looking at these situations. So in this specific case, the employer had a security checkpoint that employees had to go through to enter or exit the work site, right? And before they entered or exit the work site, there was guards at this guard check or security checkpoint that would scan everybody's badge and sometimes look into vehicles or do a inspection before they went in and out. And this caused like a delay or a line to form getting in and out of the job site. Sometimes that line would be so long that it would take employees anywhere from 10 to 30 minutes to get in there. Now, since that checkpoint was built before the employees got into the location where the time clock was, or where they started working, that time was off the clock. So this went to court. Huerta brought it to court, said that this delay should have been compensable, and the California Supreme Court agreed with them. They said that the time was compensable. It was considered hours worked because they were under the control of the employee, and there was specific supervised tasks that took place during the checkpoint process. So again, it's all about, control. How much control does the employer have over the employee? In this case, the employer with the security checkpoint basically controlled what the employee could do and how long it took them to get into the job site. So with that, that's kind of the rationale that the court took, that saying, you as an employer are controlling the employee having to go through this checkpoint. You're basically mandating it. They're doing it under your orders. So this time should be paid for them. This time is compensable at this point. So some tips on how to avoid the situation, of course. Um, Basically, don't permit any pre and post shift activities off the clock, like security screens. Log into computers. So for instance, if you use a computer to clock in and out, and when your employee shows up, they have to turn on the computer, wait for it to boot up, log in, and then clock in. That time really should be compensable. So something you could do is maybe have an exempt employee go in and have all those machines ready to go when your non-exempt employees show up, so they could just come right in, log in, or clock in, and then get right to work. If there's any kind of protective gear, safety gear, specialty gear that they have to put on or take off before or after their shift, that time is compensable as well. Um, this is an easy one. Answering emails, talking about work tasks for the day, any kind of discussion of work off the clock should be compensated as well for those non-exempt employees. Locking up and setting the alarm, this is something we see a lot in retail or restaurant settings, right? You have maybe the time clock in the back of the location. Employee has to clock out, and then they have to come in and do some tasks on the way out the door before they lock up, or set the alarm, lock up, and go. This could be anywhere from 1 minute to 5 to 10 minutes. So that time should be compensated as well. And finally, of course, cleaning up at the end of the day. All that should be done on the clock or should be compensated for, or you run the risk of, you know, having some wage and hour penalties levied on you. So be very careful with that. Any kind of work or things that are considered work or considered under your control that the employee has to do while they're off the clock, be very careful with those things because they could very well be compensable time. Now, some other things came out of this case, of course. Um, In this specific case, in the Huerta case, after the security check, employees have to drive 15 minutes before reaching the employee parking lot. So this was located, in a remote area. There was that guard shack in the front. Then they have to drive an additional 10 to 15 minutes. It was a nature preserve, so they had to follow, the speed limit requirements. And basically, it was a long time between the time they got into the guard shack and the time they got to the parking lot to get ready for work. Now, the court found that that drive time was not compensable. Basically said that's not hours work because, you know, basically, I mean, the the employer did not have control over how long that drive took, right? Basically, it's they consider it almost like a commute time. So we know commute time is not compensable. Same thing happened with that drive from the guard shack to the parking lot. Something else that came out of this case as well was there was on-duty meal breaks. So in this case, there was a collective bargaining agreement between the employer and the union that stated that the employees had to remain on the premises for meal periods but were not paid for that. And if you've been through any of our labor law updates before, wage and hour updates, you've heard us say that, you have to relinquish control of your employees during meal and break periods. So in other words, they're free to do what they want with that time, whether it's leave the premises, stay on, go to their car and take a nap, whatever it is, we have to relinquish control of them. So in this case, the argument was, well, there was a collective bargaining agreement between the employer and the union that said that that was fine. Well, unfortunately, even the collective bargaining agreement, you cannot waive certain rights that an employee has. And this is one of those rights. So again, if the employee, in this case, if the court found that the employees had to be paid for that on-duty meal period, even though the collective bargaining agreement said otherwise, because that was a right that the employees could not waive even under that agreement. So how do we avoid the situations? Well, keep in mind, on-duty meal periods, they're very rarely permitted, right? And usually you have to show that the nature of the work doesn't allow you to let the employee take a break or leave the work location. So again, that is up to you as an employer to prove that, and usually a pretty high bar to pass. So we always recommend, let your employee do whatever they want with their meal times, with their break periods. So in this case, that example, we showed that it was a 15-minute drive from the guard shack to the parking lot. So the argument would be like, well, it's 15 minutes to drive from one place to another. What could they possibly do with that time? We might as well make them stay. Not necessarily. You have to give them the freedom to do what they want. So if they chose during their half-hour lunch to go over there and just drive around the road or something like that, that is very much their decision. They're allowed to do that if they choose to do so. Again, keep in mind, if you don't provide that meal and rest period or you don't provide enough time, make sure that you're aware that that premium paid is owed at their regular rate of pay. And again, it's in addition to time spent working during the meal break. So in other words, if you're paying that premium pay for somebody that worked or that was asked to work through their meal period, you're going to pay that premium pay on top of their hours worked. So we always compensate the hours worked, and the premium pay is almost like a penalty or something that's paid beyond that or on top of that. All right, so with that, let's move on to some health and safety updates. And this was a big year for that in the state of California. A couple things that came about this year or that we see coming our way is workplace violence and heat illness. Now, meantime, though, I did have another question that came up that states if an employee knows when they should take a meal break, is the employer or employer responsible to ensure that they take their meal break on time? And that is, that's really the million-dollar question, right? I mean, as employers, we are not the meal and break police. So it's not up to us to force the employee to make that meal break. It's just up to us to provide the opportunity for them to take that meal or rest break. So if you have a policy that says, employees should take their meal break by the fifth hour and the employee refuses to do so, or, basically works through or doesn't do it on their own accord, you may be able to document that and not pay that penalty. The safest, honestly, the safest thing to do may be to pay the penalty, but also to use corrective action to address that behavior, right? Because at that point, if you have a policy that states they do have to take their meal and break time when assigned and the employee refuses to do so, they're basically going against your company policy. So that may be the best way to address that. So again, as employers, we're not the meal and break police. We don't have to, stay on them to make sure that they take their meal and rest breaks. We just have to make sure we're providing them the opportunity to take those meal and rest breaks and not assigning them work, not asking them to stay. And again, the good thing to do with that too is if you have any other middle managers, supervisors, foremen, that sort of thing, make sure that they're familiar with the requirements for meal and rest breaks so that they're not, pulling people out of their breaks early or their meal breaks early or delaying them from taking them because those can be pretty costly mistakes. All right, jumping on to those health and safety updates. So the first one we're going to talk about is the Workplace Violence Prevention Plan requirement. Now, this one came into place effective July 1st, 2024. So the law says that by July 1st, all workplaces, with very narrow exceptions, had to have a workplace violence prevention plan in place and have all their employees trained on it. Now, if you haven't done this yet, don't fret. There's a lot of employers out there that haven't done it. Just it's one of those things that you want to get started on as soon as possible. And I did mention there are very limited exceptions, very limited industries or workplaces that do not need this. One of them is, say, the medical field or medical locations, because guess what? They've already had a workplace violence prevention requirement in place for a long time. The other one is corrections or law enforcement facilities too. Those are other ones that have already had that in place. And the last exception that we have out there is places of work that are not accessible to the public and have an IIPP in place and have less than, I believe, 10 employees is what it is. So again, that's a very narrow one. And the thing about that is that the state of California or the law did not really define what not accessible to the public is. It's not defined in the statute. So, the questions come up. It's like, well, what if, you need a badge to get into the location? Does that mean that it's not accessible to the public? I don't know. Again, we're waiting for more FAQs, for more information from the state to see what that means. So the question with that is, what happens if we don't have a workplace violence prevention plan in place right now? Are we in trouble? Well, I don't think Cal OSHA is going to go door to door, asking people for their workplace prevention plan. However, if you do happen to have a visit from Cal OSHA for another reason, say you have an accident, fatality, somebody reports or anything like that, you can be pretty sure that they're going to ask to see that. So again, it's better to get started on that and make sure that you have that taken care of rather than not. Now, another question popped up is where can I get a sample of an IIPP? Injury and Illness Prevention Plan. The state of California does provide that. They do have a template for that available. I can't remember what the web page is right now, but take a look at employers.org, our website, under the free resources. I believe we do have some links there where you can go to the state of California and see those different templates that they have available. All right, so when it comes to workplace violence prevention plan, let's talk about what constitutes workplace violence or what are some examples of that. So these are the things that we have to look out for, prevent, and, basically document or report. The first one is if any physical attack that occurs at work with or without a weapon. So again, a coworker punches somebody else or hits them with something. That is an example of workplace violence. Any threat of physical force or use of weapon. So if you have two employees arguing, one tells the other one, I'm going to beat you up or I'm going to hit you over the head with this chair. Guess what? That is considered workplace violence. Sexual assault or unwanted verbal or physical sexual conduct. So now we've already addressed this kind of stuff in harassment and discrimination laws, right? And policies and regulations, that sort of thing. Well, another layer to that now, if you have any kind of sexual harassment complaint, it could very well also be an example or a case of workplace violence. The statute also lists animal attacks. So if you're in a location that's maybe a vet's office or dog boarding or a delivery driver, UPS or a mailman or something, you're attacked by an animal, guess what? That is an example of workplace violence. And that applies to that question that just popped up too. If you have an employee that goes to a client's house and gets bitten by a dog, that very well is also an example of workplace violence. Again, that falls under, that example, like those UPS drivers that go door to door delivering things. Well, if you have salespeople that go door to door, or somebody that goes to a client's house and they're bitten by a dog there, or whatever it is, that is an example of workplace violence that you have to find ways to address and prevent in the future, of course, but also have to document that in your workplace violence prevention plan and in your log. So, another question pops up again, if you work in the medical field and sometimes the staff gets verbally harassed by patients, what's the best approach in training staff and ensuring their safety in the situations and that the employer is not in control? In that case, I mean, it's our responsibility as employers to provide a violence, a harassment, discrimination free workplace. So again, it's that training that we give the employees in reporting. And, I mean, it's hard to control what other people are going to do, right? Whether it's clients, whether it's patients, or whatever it is. So in that case, we maybe train our employees or find a way to train them in de-escalation techniques, or recognizing that when it's getting to that point, calling in a supervisor, somebody that is better trained or better equipped to deal with that situation. Um, Now the other one, I mean, what if an angry employee yells out, "I will do what I need to do"? Not really a threat. I mean, depends on the circumstance, right? If it's part of a conversation that says, "Well, what are you going to do? Hit me?" And they respond, "Well, I'll do what I need to do." You kind of have to look at the whole picture, right? So in that case, if it's part of a threat or part of a, you know, escalation of a threat or something, it could be if it's just an employee that yells that out because they're frustrated, or you're telling them, "Hey, you need to do this task a specific way," and they yell that out. It may not be workplace violence. It could violate some other policies as far as conduct, professionalism, that sort of thing. So some key requirements of that workplace violence prevention plan, of course, you have to keep in mind. First one is you have to have a written plan, much like the IPP if you're familiar with, or if you created a COVID prevention plan, um, then same thing. You have to have a written plan. The different thing about this, though, as opposed to the IAPP or COVID prevention plan, is we have to solicit employee and union, if you're in the union environment, involvement in creating the plan. So in other words, you have to, survey or let your employees have some input into some of the risks, threats, hazards, that sort of thing, and address those whenever possible in creating the plan, as well as any kind of suggestions or any kind of ideas that they have. You have to have at the very least, annual training, right? We also say, if there's any change, any kind of new situation, anything that arises throughout the year, retraining may not be a bad idea at that point, but at the very least, you have to have annual employee training. There also has to be periodic inspections and hazard corrections, as well as safety meetings, and those must all be documented, and that documentation has to be saved. You have to investigate any workplace violence incidents, similar to any claims of harassment. You have to investigate those workplace violence incidents. And there are record keeping requirements. I mentioned that violent incident log, and that's similar to if any of you fill out those OSHA logs, those OSHA 300 logs, very similar to that, where you list, the date it happened, what type of violence it was, et cetera, without putting any specifics that could identify the people involved. And for those of you that are interested, we do offer a DIY package on our store to help you get started on that. Now, if you haven't done your workplace violence prevention plan yet, again, don't fret, just get started on it as soon as possible. And if you have any incidents that occurred before July 1st, those are not ones that you have to log. It's anything from July 1st going forward. That's when this requirement came into place. So if you want to log anything ahead of that, feel free. But again, the requirement this was not a requirement until July 1st of this year. So that's when it started. All right, the next safety development that we had was the indoor heat illness plan. And this is something that Cal OSHA had been kicking around for some time now. Honestly, they've probably been kicking this around since before COVID hit, which of course we know delayed a lot of other things because all focus was shifted to that, and rightly so. So in this case, this came basically on June 20th, Cal OSHA voted to adopt an indoor heat illness standard, and that'll apply to most indoor work areas, and these measures will come into play whenever temperatures reach or exceed 82 degrees while employees are present. So This is really aimed at places like manufacturing facilities, warehouses, kitchens, and restaurants, basically places without full AC or where temperatures can reach a hazardous level. Now, there's not a specific date yet as to when this will take effect, but it could be as early as August of this year or as late as October. So we're just waiting for approval from the Office of Administrative Laws. They're the ones that basically take a look at these regulations when they come through, see what the impact is going to be, and see, if there's any issues with that. So again, keep that in mind. Sometime between August and October is when we're going to have one of these in place if you're in one of those locations where heat can reach a hazardous level, right? Now, as you know, if you have any outdoor employees or outdoor workplaces, you know that you're already required to have a and maintain a written heat illness prevention plan. The indoor one, honestly, is not much different. And the new template actually that Cal OSHA has put out basically combines both the indoor and the outdoor one. So again, if you've done an outdoor heat illness prevention plan, the indoor one is pretty similar to it. So um, this is something that I think most places will be able to address because honestly, a lot of it tends to be common sense, right? So some of the things, for example, some of the essential requirements are having drinking water accessible to employees, right? Having cool down areas. So if you have a facility like a manufacturing facility, say, I used to work at a window manufacturer and they had the places where they did the glass that was very hot. Um, we also had a break room that was air conditioned. So again, having that cool down area, having an air conditioned area where employees can go recover, rest, or cool down. Having emergency response procedures, what do you do if someone shows any symptoms of heat illness or someone complains of heat illness? What are the steps that you take? And also having acclimatization measures. So what that means is if you have a new hire, for instance, that's just coming into your workplace, what measures do you take to make sure that their body gets used to those new conditions? So in other words, do you maybe provide extra breaks for the first couple of weeks? Do you check in on them, more often than not? What do you do? Just what are those measures going to be to make sure people are adjusting to those new conditions? Now, the requirements for employers again is to have that written heat illness prevention plan, provide training for employees and supervisors. They didn't give us really a requirement for how often this training should be. At the very least, I would say that should be yearly. If you have specific seasons or specific times when that heat is more of an issue, that may be a good time before that starts to, have a refresher training on that. And then, of course, there's other requirements when that temperature exceeds 82. When you exceed 87 degrees, or 82 degrees, but they're wearing restrictive clothing, then there are additional, cool down measures, right? Additional breaks, perhaps, um, that sort of thing. So again, even if the temperature is only 82, but your employees have to wear a lot of safety gear, maybe, say, for example, a welding shop or something where they're wearing those heavy welding leather jackets, that would be something to consider to have additional measures in place for employees to cool down and to keep them safe. All right, moving on to some changes in employee rights and protections. And these will deal with things like pregnant workers, harassment, and artificial intelligence. So starting with pregnant workers, this one we actually got some movement from the federal government. Now, usually when we talk about labor law updates, we're talking about California laws and California changes. And this one will discuss a federal law. So this is the Federal Pregnant Workers Fairness Act, which passed in June of 2023 and came into effect June 18th of this year. Now, this act was modeled after the Americans with Disability Act and applies to employers with 15 or more employees. And basically, this one is a little bit more expansive or covers more than the ADA. Um, and this is because it not only addresses disabilities, but also addresses what's called limitations. And these are things related to pregnancy, childbirth, or any related medical conditions. So things such as morning sickness, migraines, the need to go to prenatal appointments, that sort of thing. All those are protected under this new act. As a refresher, California already has several protections or a lot of protection for pregnant workers. Actually, pregnancy is considered a protected class in the state of California. So in California, if you have 5 or more employees, you have to reasonably accommodate an employee that's disabled or affected by a pregnancy, as long as it's certified by their healthcare provider, right? So if a healthcare provider tells you that this person has to be taken off of work because of their pregnancy, or they need, certain accommodations like coming in late or have doctor's appointments or what have you, then this is affected by that, right? The state of California also provides up to 17 and a third weeks, 4 months, of pregnancy disability leave. And this as long as it's certified by the healthcare provider. Again, healthcare provider can say, this person needs to be off of work for a month prior to their delivery date, or it could be intermittent. They could say, well, this person needs to, work shorter days or what have you, right? And of course, it also provides protections against harassment, discrimination, or retaliation against any kind of pregnant employees. Now, before I move on to the question came up, how does this new pregnancy law affect the use of FMLA or CFRA hours? So for FMLA or CFRA, you're going to follow your same procedure. If someone presents you, telling you they have any kind of restriction, they need to miss some time or what have you, provide them the documentation and follow that procedure as needed. Now, keep in mind the state of California, pregnancy disability and CFRA cannot run at the same time. So you're either on pregnancy disability or you're on CFRA. They cannot overlap. FMLA and pregnancy disability can overlap. So that's a difference. So if you have a specific situation on that, give us a call on the hotline so we could walk through it and walk through the specific facts of your case. Now, the question is, well, you talked about the federal protections, you talked about the California protections. California is usually more protective. So does this federal act have any impact on California employers? And this is one of those weird cases where the federal government actually came out and offered more protections than the state of California did. So yes, it does have some effect. I mean, the EOC regulation is actually more protective than what was offered in California. So the thing about this is that Pregnant Worker Fairness Act specified that if you have 15 or more employees, you must temporarily suspend essential job functions if the pregnant employee cannot perform them. So typically for pregnancy disability, if an employee cannot perform an essential job function, you know, the reasonable accommodation would be to put them on a leave of absence, right? Well, in this case, the federal government said if an employee cannot perform an essential function, then you have to temporarily suspend that essential function and either reassign them to another position or just take that function away from them so that they can continue working. So that one, again, goes beyond what California required. The other one is providing certain predictable assessments. So in other words, pregnancy, if they have to carry water with them, take additional longer breaks for eating or restroom breaks or that sort of thing, provide seating when standing is required or standing when sitting is required. All of those things are something that we have to provide, even if it's not required by a medical professional. So again, if it's predictable assessments, things that we commonly see or require with pregnancies, that's something we should be providing even without the request of a medical professional. And again, you know, if it's one of those predictable assessments, we don't have to, or we cannot, should not, or don't have to request a medical certification. So if you have an employee let you know that they're pregnant and that they need to take, an extra bathroom break here and there or carry water with them or whatever, you should not request a doctor's note specifying that. You should just provide that accommodation for them as requested. So again, seems a little vague, right? And it could kind of place another burden, but again, it's these predictable assessments. So we're going to deal with it on a case to case by case basis, and also make sure that your supervisors, your foremen, your lead people are trained on this to make sure that they're not running afoul of this new requirement. So example on this, we have an employee named Erica who's pregnant. She presented a doctor's note saying that she can no longer lift for the remainder of her pregnancy. Lifting is an essential function of her job. How do we respond? Well, in this case, according to the EEOC, if a pregnant employee is temporarily unable to perform one or more essential job function, you have some options you can do. You can offer light duty, you can change their work assignment for up to 40 weeks unless you can demonstrate that it places an undue hardship on you as an employer. Again, we can't just automatically offer a leave of absence like the ADA, FEHA, or the Pregnancy Disability Leave Act require. We have to go through these other options first to keep them working. And keep in mind, I mean, undue hardship, we like to think it's like, well, it's gonna lower my production, it's gonna make things harder on my other employees, that sort of thing. I mean, usually it's a pretty steep hill to climb. So we always recommend, if you're gonna argue that something's an undue hardship on you as an employer, consult legal counsel. make sure that it is a defensible position for you to prevent any kind of claims of discrimination or retaliation down the line. Best, of course, best advice would be, look for other alternate light duty or see if you can change a work assignment for that time. But if you really do believe that it is an undue hardship and you can't accommodate that, consult with legal counsel just to make sure you're not going to be in trouble down the road. Now, something else related to pregnancy, of course, is lactation accommodations. And California already has a lot of protections when it comes to lactation. So for CA members, we do have some resources like a sample form and that sort of thing. We also do have some other information available on our website for everybody else to access. There was also some changes back in 2022, the federal, what's called the Pump Act. And basically, the regulation provides that you know, in California, you have to give people the the, the ability to lactate or express milk, you know, during their breaks, take additional breaks as required to do it. You don't have to pay them for those additional breaks. You can ask them to clock out. You have to provide them a private place to do that, not a bathroom. It's got to be a private place besides a bathroom to do that. Access to refrigeration in order to store the milk, that sort of thing. Well, the new regulation by the federal government, of course, affects this as well by saying that a lactation accommodation can also include letting the employee nurse their child during work hours as long as the child is in what they call close proximity. Now, did they specify close proximity? Of course not. They didn't tell us it's got to be within 1 mile, 2 miles, or whatever. So what we consider close proximity is if your place of employment has an on-site nursery or an on-site childcare facility, in that case, you would have to permit the employee to nurse during work hours. Or if the daycare center is right down the street, you would permit the employee to clock out, unless it's during one of the regular breaks, to clock out and go nurse their child during the day. So this is also an accommodation, a lactation accommodation as well. Again, they didn't really give us a clear definition of what close proximity is, but for this, we're going to use our common sense. If it's something that's 5 minutes away, that's probably considered close proximity. If it's something that's half an hour away, may not qualify. So again, keep that in mind. Talk to your employees, discuss the situation, discuss the accommodation, and talk to them to see what they need and what you can do as an employer in these cases. Now, another change that came about this year, the EEOC also changed or offered new guidance on harassment. And it's been 25 years since they made any change to this. So this is big news, right? They gave us 77 examples and clarifications on what constitute harassments. And this could be things like intrusive questions about sexual orientation, gender identity, gender transition, or intimate body parts, harassment of LGBTQ plus workers, and this includes things like access or denying access to bathrooms consistent with their gender identity, or if you intentionally or repeatedly misgender them. So someone's transitioning, you don't call them by their preferred pronouns, and you do it purposely repeatedly, that is considered a form of harassment now under the EEOC. It could also be based on things like pregnancy, childbirth, or related medical conditions. And something to keep in mind too is harassment can also occur during remote work environments. Now, having worked remotely for a while in many industries here in California, especially since COVID, we know that harassment is not just something that happened in person. It could occur online, it could occur over the phone, that sort of thing. The EEOC came out and basically put it in writing that said harassment can occur in those remote work environments. And as we know, sometimes when we're talking on the phone or we're talking online or emailing or whatever, it's a lot easier to cross certain lines, right? Get a little bit too comfortable, say things that we normally wouldn't. So be very careful with that. Make sure that your harassment discrimination policies are very clear and understood by your employees and your management team. I also had a case come about regarding artificial intelligence. This is something that's been talked about in several, different ways in the last couple of years, especially since ChatGPT and other forms of artificial intelligence came into play. Well, we had a legal case on this, and this was Mobley versus Workday. So in this one, the EOC argued that an AI company provided resume screening services that could be directly liable for discrimination. So in other words, in this case, it was a class action lawsuit in which the plaintiff alleged that Workday engaged in a pattern or practice of discriminatory job screening that disproportionately disqualified African Americans, individuals over 40, and individuals with disabilities from securing employment, violating Title VII of the Civil Rights Act, the ADEA, the ADA, and California state law. So they ran afoul of all kinds of laws in this case. So, and basically what happened is, they contacted this company and said, we want an AI program to screen resumes for us. Sounds innocent enough, right? Well, somehow the way this was set up or this was written, it was screening out or disproportionately affecting people in these protected classes. Was it done on purpose? Who knows? Maybe, probably not. However, the fact that it had this disparate impact on these groups was enough to make it problematic, make it illegal in this case. So, again, our recommendation is if you're going to use artificial intelligence for things like resumes, screening, or anything like that, proceed with caution, right? Be very careful with using AI. Keep in mind this is relatively new technology. We still don't know what it's going to do. So maybe if you're going to use it, you know, do some auditing on it to make sure that you're not having a disparate impact on certain groups. Um, if you're a company leader, make sure you stay abreast of those developments, right? And maybe form an AI committee within your company to see how you're going to use it, when it's going to be allowed, how you're going to address any issues that come about with it. And if you're in a industry or workplace that can use AI, make sure you have a policy and training for your staff as to when it's permissible to use AI and when you're going to prohibit it from being used. Now we do have a sample AI policy for CEA members on our forums page if you want to head start on crafting one. If you have any questions on it though, give us a call on the hotline and we could talk about it as well. Now, speaking of minimum wages, one that's been on the news on and off for the last couple of months has been the healthcare minimum wage. Now, this is one that was initially supposed to come into into place in the middle of the year, right? And the goal was for healthcare workers to earn up to 25 or to earn $25 an hour. That was going to be the minimum wage. Initial wages were going to range from 18 to 23, and that was supposed to take place earlier this year. Now, due to the California's financial situation, this has been delayed. Now, if certain parameters are met, this minimum wage will come into place on October 15th. If not, then it'll be pushed all the way out to January 1st, 2025. Again, this is going to be based on California's revenues. Now, in order to be an exempt employee in the healthcare industry, employees must be paid 1.5 times the healthcare minimum wage or 2 times California's minimum wage, whichever is greater. So, again, this is going to kind of throw a few more calculations into the minimum wage landscape in California, right? And there are some exemptions. I mean, in order to be exempt under the new law, covered employees must be, again, have to in order to be exempt, you have to be paid either 1.5 times the healthcare minimum wage or 2 times California's minimum wage. So again, mark it on your calendar. It's either going to be October 15th or January 1st when this comes into play based on the financial situation of the state. Another law that kind of got our attention this year. Now, this one was only proposed. It was basically placed on the suspense file. It didn't pass. But this is something that's probably going to be revisited again in the future. So keep an eye on this one right around September, October, November, see if it resurfaces again. And this one was the right to disconnect. So what this one stated basically was that um, you couldn't require employees to respond to you, engage in work, do anything during non-working hours. So basically, this meant that you couldn't call your employees with any questions about work. Hey, where'd you leave this? Hey, do you know where this file went? Et cetera, during off work hours. And if you did call and they didn't answer, didn't respond, you could not take any corrective action against them. Now, this also applied to exempt employees, which would have made it, very difficult, right? Because sometimes our expectation is that you're exempt. You're basically on the clock, right? You're always waiting to help. You're never off the clock if you're exempt, basically. So, with that, um, this right to disconnect would basically give employees a right to ignore communications during non-working hours, and if there was any kind of corrective action for not responding, or if there was repeated attempts, they could file a complaint with the labor commissioner for a pattern of violation. So again, this did not pass, but it's something that was proposed. placed in suspense file. So we're keeping an eye on it to see if this one comes back. And again, if you have remote workers or if you're in a situation where you tend to contact employees after hours to discuss the next day or anything like that, this is something that could have an effect on you. Now, this wouldn't apply for things like scheduling and emergencies or anything like that, but for regular work topics, this is something that could very much limit your communications with employees during off hours. So we'll keep an eye on this. If something develops on it, keep an eye on our blog. We'll send something out. So what's next for California employers? Well, I mean, the important thing is always make sure that you're paying your employees properly and capturing all hours worked. This includes things like, if you have a security checkpoint, if you have inspections before or after they start work, if they have to don or doff any special gear, make sure we are correctly compensating employees for that. When it comes to workplace violence prevention plan requirements, make sure we're in compliance with them. Again, this was required effective July 1st of this year. If you don't have one put together yet or in place, now's the time to get started on that. Get that employee feedback. Survey your employees, see if they have any complaints, any concerns, any suggestions. Make sure you get that information, and wherever it's feasible, incorporate it into your plan. Consider policy and training updates regarding pregnant worker accommodations and harassment. We always recommend, train your supervisors, train your leads, train anybody in your management team on what employee rights are, what those requirements are, what their responsibilities are to make sure they don't inadvertently get you in trouble. So that training goes a very long way. And also let them know, hey, if you don't know the answer to a question by an employee or whether an accommodation should be done or not, escalate it immediately. Don't just give a yes or no answer. Get help, get clarification before we move on. And also stay tuned for ongoing developments. I mean, sign up for our CEA blog, whether you're a member or not. Anything that comes up, any new development, we tend to send something out as soon as possible to make sure that we keep you informed of any changes coming up. So with that, again, I'd like to thank everybody that took place. I'd like to thank the Central Valley counties for putting on this webinar. I'll leave this on for just a sec so you can see what your county hotline number is. If you have any questions about this presentation, even if you don't think about it right now, even if you're walking away from this and you think, what the heck did he say again? That's the time to give us a call, right? And if you're interested in more information or any help beyond the hotline, we do also offer memberships, anything from monthly memberships all the way to what we call the ultimate membership as well. So different levels depending on what you need there. So again, you can give us a call or go onto our website to see what the different benefits and different coverages are based on your membership. We also offer, if you find yourself in a situation where you need additional HR help, maybe somebody on site, maybe you got your HR generalist or managers on leave of absence, or they left, or you're between people or just getting started. We also offer a service called HR Assist, where we send an HR professional either on site or to help you virtually to cover somebody's absence or to get started with your HR department or get another set of eyes on your things, whatever it is. We can have an HR professional on site for you to help you out. So do have a flyer at employers.org/HR assist if you have any more questions for that. Now, Anna did mention there would be a survey, and since I don't want to make a liar out of her, here is the page for it. So if you scan that QR code, it'll take you right to the survey. I believe it's 3 short questions if I'm not mistaken. So, let us know what you thought. Let us know what you liked about the presentation, what you didn't. Let us know what you'd like to hear about in the future. There's no such thing as bad information. So please drop us a line. Let us know what you thought. And of course, for those of you that are with us for continuing education, I do have some codes for you. If you are participating through HRCI, your code is 675221. That's 675221. And if you have your certification through SHRM, it's 24-F4G5Q. 24-F4G5Q. And as I always say, whatever you do, if you're with SHRM, do not forget that dash or they'll be very mad at you. So with that, I'll check to see if we have any questions outstanding out there. Looks like hopefully we addressed them all. If anything comes up, again, please give us a call on the hotline. I think that wraps it up for us. Anna, any final words before we go?
I think that was it. I do, excuse me, allergies today. I know you feel me out there in the Central Valley, our friends. So yes, really want to encourage you to take that survey. It is less than a minute to complete. I think a lot of people do it in 30 seconds. But that really does help us with the feedback to continue to hopefully exceed your expectations with trainings like this. I do want to direct your attention over to the chat in case you didn't already see it. I did put the link for the next training coming up on August 22nd. It is conflict management, fierce and crucial conversation. So this is a really great training. Encourage all levels of your team to come and join just to make sure that your work culture is really thriving. And let's see. And then I did drop some links in there if you weren't paying attention to the chat with the workplace violence DIY package. So that includes the recorded training as well as the toolkit. So those kind of work hand in hand to make sure that you are guided every step of the way to make sure that you have a customized plan. And then the Cal OSHA heat illness prevention resources also in there. So with that, I want to say thank you to Eli for sharing your time and expertise with us today and for managing those questions so expertly. Thank you all for showing up live and bringing those questions. This is really great. I love this time because you can just kind of fire anything and and hopefully we can get to the information that you need. If you didn't get that question answered, please make sure to refer to your handout. There's a bunch of different hotline numbers depending on the county that you're in. Nellie, I owe you an email. I promise I will get back to you right after this. And we also want to thank our partners over at Central Valley for collaborating together and making this hotline and trainings like these come together. So with that, we hope to see you all in August and enjoy your day. Cheers.